Welcome to our new series on AI. Over the coming months, we'll explore the key challenges and opportunities within the rapidly evolving AI landscape. Today, we will focus on the basics of the EU AI Act. My name is Tom Gates, and I'm a senior associate at Reed Smith. And I'm joined today by my colleague, Sophie Goossens, a partner at the firm. Sophie and I work together in Reed Smith's Entertainment and Media Industry Group. Sophie, thanks for joining us today and for taking part in this quick-fire round of AI questions. So to start off with, Sophie, what is the EU AI Act?
Hi, Tom. Thank you. Well, the EU AI Act, in one sentence, is the EU's response to the question, how do you regulate AI, and the first comprehensive regulation on AI by any major regulator.
And how does the EU AI Act work?
Well, the Act creates a framework of obligations for entities that are making and using AI, ranging from a simple transparency requirement all the way to a full CE marking. The obligations apply or don't apply based on 4 risk levels of AI systems: low, limited, high, and prohibited. And in addition to that, the Act also created a special set of rules which was enacted to regulate what the EU decided to call general purpose AI. General purpose AI are those models that can be used to do a variety of tasks. For example, most of the mainstream LLMs that we are using today would likely qualify as a general purpose AI system.
And when will the EU AI Act enter into force?
It should enter into force in 2026. To be more precise, it will enter into force 2 years after the Act gets published. As of the date of this video, the publication hasn't happened yet, but it is expected during the course of July 2024 to become applicable in July 2026. I should mention that a shorter time period was created for prohibited AI. That period will be of 6 months. And you also have some longer time periods for AI systems that are already in circulation within the EU as of today.
So now we understand the timelines. Who actually needs to comply with the EU AI Act?
Well, the Act has listed a number of stakeholders and gives us a number of categories. If I try to list them all, you have the providers, the deployers, the importers, the distributors, the product manufacturers, the authorized representatives, and finally, the persons that are affected by AI based in the EU. But out of all of these categories, 2 are really important, and they are the focus of the EU AI Act. These 2 categories are the providers and the deployers. Providers are those who develop AI systems with the intention of placing them on the EU market, either themselves or under their own name. On the other hand, the deployers are those natural or legal persons using AI under their authority in the context of a professional activity. So providers develop, deployers use in a professional capacity.
And so now we know who it applies to. Where does it apply? It's called the EU AI Act, but does it apply outside of the EU?
Well, actually it does. With respect to the geographical coverage of the EU AI Act, there are 3 main rules to have in mind. First rule, that providers, so the developers of AI systems, will be captured under the Act if the AI system is on the EU market, irrespective of whether they are established within or outside of the EU. The deployers, on the other hand, should only be captured if they are based in the EU. There is one tiny exception to this rule, which is that although providers and deployers might be situated and located outside of the EU, if the output produced by the AI system is used in the EU, then the providers and the deployers might be captured under the EU AI Act, in particular where that output would have been subjected to AI law if it had been produced within the EU.
And the EU AI Act itself sets various rules in relation to AI systems. But how does it define AI systems?
EU AI Act gives a rather long and complicated definition of an AI system in order to keep it on par with definitions from other international bodies, including the OECD. But the key element of that definition is really the capacity for an AI system to infer from the input it receives how to generate outputs, such as predictions, content recommendation, or any other type of decision. The definition that exists currently in the Act has been criticized for being extremely broad and running the risk of applying to a lot of IT systems. In response to that, the EU has specified within the Act that it was not intended to cover simple traditional software systems, and it also undertook to publish guidelines on the application of the definition of an AI system.
Okay, so are there any so-called AI systems which are out of scope of the EU AI Act?
Yes, a number of exclusions exist, and the main one are as follows. First, the Act won't apply to military AI or AI used for defense or national security purposes. The Act won't apply to AI systems that are created for the sole purpose of scientific research and development. The Act also won't apply to any research, testing and development, or any other activity that is of a prior to putting the model on the market. So it's before the model is put on the market, it doesn't need to respect the EU AI Act. There are also limited exclusions with respect to low-risk open source AI. And then, of course, finally, the Act does not apply to anyone using AI in a purely personal, non-professional capacity.